You may have seen the recent story in the news about how the presenter and wildlife enthusiast Anneka Svenska was approached by police after they received a complaint from a company which alleged that Anneka Svenska had made false allegations about the nature of their operations. And what ended up happening was police attempted to get Anneka Svenska to agree to a community resolution order, which she subsequently refused to do. Now, if you have a look on, particularly the Free Speech Union's website or indeed other YouTube channels, you'll see a lot more detail about this case and the questions around it and so on. This video isn't specifically about that case. It's not about the conduct of the police, and it's not specifically about the rather pertinent questions of free speech which are related to this case, and of course the rather interesting issues around the Online Safety Act. Now, those of you who know me rather well can probably hazard a pretty good guess as to what my views on those matters might very well be. But this video isn't about that. It's instead about the issue of where animal welfare law comes from and how it has evolved over the centuries. If we were to take a look at the period before 1800, then what we actually see is there's basically no animal welfare law in this country. Instead, the general kind of approach was that animals were seen largely as property. And we've got to remember that prior to 1800, the nature of the economy was that it was largely agrarian. And animals were basically seen as obviously a source of food, but also a form of labour, because of course a lot of farm work relied on animal labour to perform all the various tasks and such like. The other thing during this period before 1800 was that there wasn't really that much of a culture of state regulation and state interference. We're dealing with a governmental approach which was what we call laissez-faire by and large. Also during this period, we're actually seeing how animals were essentially a kind of a form of entertainment, or could be the form of entertainment for people. So, for example, if you were to have a look at the particular Tudor period, you'd see sports such as bear baiting being particularly popular. Nevertheless, prior to 1800, whilst there wasn't any welfare law as such, there were some individuals who raised rather important questions. For example, back in 1693, the philosopher John Locke raised the issue of animal cruelty. And in Locke's view, animal cruelty was a concern not necessarily because of the way in which we might understand it today, but rather because John Locke understood animal cruelty as what we might consider to be a slippery slope. In essence, John Locke believed that if you allowed cruelty to animals, then this would actually feed into and develop cruelty to humans. But in 1789, Jeremy Bentham asked a more pertinent question. And for Jeremy Bentham, the issue wasn't whether animals could reason, it wasn't whether animals could talk, it wasn't anything particularly to do with the intelligence of animals. No, for Jeremy Bentham, the key question was whether animals could suffer. And so Jeremy Bentham's argument and thinking in this context, it actually introduced a moral issue. It introduced a moral test over animal cruelty and suffering. And of course, it was in the decades after Jeremy Bentham that we begin to see the first types of animal welfare legislation coming in. So, of course, during the 1800s, we have the Industrial Revolution, and we're seeing more and more people moving into towns and cities as the economy develops, and of course we became more industrialised and people are working in factories and so on. And it's during this time where, as more people are moving into urban areas, that the treatment of animals became more visible. And so any kind of mistreatment or cruelty is much more likely to be seen by more people. At the same time that industrialization is going on, we have the emergence of a kind of Christian evangelicalist movement. And there's this push for what we would call humanitarian reforms in different parts of society. And of course, it's during this time, during that period of the early 1800s and into the 1830s, that's where we see, campaigns to abolish slavery and such like. And this is where the attempt to introduce animal welfare legislation came in at the same sort of time. Now, the first animal welfare legislation that was introduced was in 1822, known as Martin's Act. This piece of legislation primarily focused on farm animals. Just a couple of years afterwards, we see the Society for the Prevention of Cruelty to Animals being formed. This would later become the RSPCA after it received support from Queen Victoria. And of course, the SPCA was involved in performing investigations and campaigns and such like to raise awareness and help tackle issues to do with animal cruelty within the context of Martin's Act. However, in 1835, there is the Cruelty to Animals Act that was introduced. Now, this actually expanded things quite a bit more than what Martin's Act had done, whereas Martin's Act was primarily interested in agricultural animals, farm animals, the Cruelty to Animals Act of 1835 actually began to prohibit certain blood sports. So things like bear baiting, for example, which had been popular centuries prior to this, were no longer permitted. And then it's not until 1876 that additional animal welfare legislation was brought in. And in 1876, regulations were introduced which required a licensing system for laboratories that were conducting animal experiments of one kind or another. And then by 1911, there was a new body of legislation that was introduced. This was the Protection of Animals Act. And this was really the first kind of comprehensive anti-cruelty legislation that was introduced. But during this whole period of, say, the 1800s and into the early 1900s, the overall focus of animal welfare legislation had been about punishing cruelty. It was essentially reactive. And the next phase of major animal welfare legislation didn't happen until 1951, really 1951 through to, really by about 2006, although that period of 1951 to 1986 arguably saw the biggest package of animal welfare legislation. And during that period of 1951 to 1986, regulations were introduced which impacted pet shops. They affected boarding requirements such as in kennels and catteries. Riding schools were regulated more during this period. And then by the time we get into the 1980s, we see legislation introduced to protect the wildlife and also to sort of further regulate scientific procedures. But in 2006, we get the Animal Welfare Act. And this was really, really important. It introduced basically kind of sort of a duty of care. And there were 5 welfare needs tied up within all this. And these focused on things such as providing a suitable diet for animals, providing a suitable environment, allowing animals to exhibit normal behaviour. And there was certain requirements in this duty of care for owners to protect animals from pain and disease. And so when that came in 2006, I would suggest that that sort of marks the end of the second phase of animal welfare regulation and legislation. So we think the first phase is from 1822 through to 1911. I would suggest the second phase occurred from about 1951 through to 2006. And the emphasis had changed. Whereas in the first phase of legislation, it was, I would suggest, largely reactive, it was largely focused on punishing cruelty. The second phase of legislation was more focused on actual welfare. And then this brings us to the most recent phase of animal welfare legislation. So in 2021, we had the Animal Welfare Sentencing Act, and this increased the length of time someone could spend in prison for basically being cruel to animals. And the sentencing increased from just a few months through to several years in prison. And then in 2022, we had the Animal Welfare Sentience Act. And this really does mark a new phase in animal welfare legislation. And the 2022 legislation recognises animals as sentient beings. And what this in practice does is that it pushes present and future UK governments into considering how they should make policy knowing that animals are sentient. And so when we look at animal rights and animal welfare in the UK, we can see not only that this country was the first to introduce animal welfare legislation, but that it has also continued to refine and improve that legislation and to develop its thinking around that legislation. We can basically see an evolution of moral philosophy underpinned by advancements in social reform and scientific thinking. And of course, the industrialisation of our economy changed our perception of animals, as did the influence of Christian evangelicalism. So rather than valuing animals simply as economic assets, as we did before 1800, we've actually become a nation which, generally speaking, values animals more as companions. And along the way, our legislative framework has shifted from, as I've described in this video, from a reactive model to more of a preventative and governance model. Or rather from a reactive model to a preventative and then to a governance model. And we might do well to remember why we have such legislation to begin with. Thank you for listening. Please do like and subscribe, and hopefully it won't be as long until I record and publish my next video. I hope you all have a great day whilst I enjoy this cup of tea. Thank you.